Okay, Mr. Martinez, please keep in touch with your attorney. We'll see you on July 15th at 8:15 a.m. Good day to you.
And then I could call the matter involving Tara Starks, 25M44.
Protocol 25M44, People of the State of Colorado versus Tara Starks. Ms. Starks appears with her attorney, Ms. Almond. Ms. Gonzalez appears on behalf of the people. We're set for a show cause hearing and pretrial readiness. Where are we with Ms. Starks' case?
And so, Your Honor, there was a warrant that was issued. I did file a motion to quash, but I realized that the court did rule on that. I would ask, since Ms. Starks is here in person, I would ask again for that motion to be quashed, just because she has been in contact with me. She's been wanting to be able to get everything back. She is here today. She knew that this warrant is out, but she still came to court today. And so we would just ask for that warrant to be quashed. At this point, would need to be able to speak further with Ms. Starks before we fully announce ready. I can also let the court know for the show cause hearing that those are ones that the public defender cannot represent on. She would still have an ability to be represented by counsel. It just cannot go through the public defender's office. And so I would just defer to the court for that. But those would be the pieces that we are in here today. Ms. Starks has been working to try and get everything back in the place that it was before. There was the failure to appear on the last court date. And so we would just ask that the court understand that things happen and that she is here and we are ready to at least continue moving forward.
Ms. Gonzalez?
And Your Honor, I do have some concerns as it pertains not only to the failure to appear, but also the most recent report from ATC that just continues to show missed tests. I think that there's concern as to whether or not Ms. Starks is going to comply with the conditions of her bond. But with that, I would note that she is here present in person with an active warrant already extended. I did have a brief conversation with Ms. Allman earlier, and it actually looks like motions in this case were not addressed. It looks like one of the failures to appear was on June 1st, which was that previously set motions hearing. So as it pertains to any type of trial readiness, I don't think that people can call ready without those issues being handled in some capacity or the other. With that, I would defer to the court as it pertains to any type of quashing of the warrant with those concerns noted.
And I would defer to the court about resetting the motions hearing. I apologize for interrupting, but and because of the position we're in, I don't mind trying to find an off-docket setting for the motions hearing specifically. I am just trying not to have too many where it's not a substantive hearing that we are going to when it's an off docket setting.
Well, Ms. Starks missed the motions hearing. So we're going to be in a position where she either waives her pretrial motions issues or she waives speedy.
And Your Honor, we would not be able to waive speedy at this point. Missing the motions hearing is not considered a waiver of speedy. I would suggest that we reset within the next couple of weeks for a motions hearing, and we can discuss at that point if any kind of speedy issues are coming up. But I think at this point it is too early to have to do a waiver of speedy. I will note that we would not waive any kind of pretrial motions issues here. There's a reason that we file these and that we have these going forward. And so we would just be asking to reset this within the next couple of weeks. I can let the court know any dates that I have available for us to be able to have that motions hearing, but that would be my request.
Well, it does not appear as if the motions were filed in a timely manner. So what happened there?
Give me one moment. And I apologize. Because of the record that Ms. Gonzalez had made, I believed that there were testimonial motions that were filed at this point. I see now that there aren't any. And so I just became mixed up on which ones were filed. And so, again, I would ask if we could have a brief reset maybe for the pretrial readiness here, just so that I can have discussions. But again, we would just ask that the court note that she is here. She has been working with me to get everything moving, and we would just need to have a conversation. Our conversations recently have been making sure that we try to get everything going for this warrant, but she did know that it was here when she came in.
Well, as far as getting everything moving, I guess I don't understand what that means if she's still not doing her tests. I received the same report that Ms. Gonzalez referenced, and it says that she still is not testing. I know she did 2 tests, so I disagree that she's been scheduled for 34 and she's missed 34. But in any event, we're looking at 32 missed tests, which is a condition of her bond. So
And I guess what I mean is that
this is sort of puzzling.
what I meant is that there was a pending offer here. And so we would just need to be able to get any kind of paperwork, any discussions with that offer here. That is what I mean by getting this moving forward. At this point, I've still been working with Ms. Gonzalez so that we can have an offer here before we get to trial. And that's why I would like to be able to have that one additional pretrial readiness so that she does not lose on her ability to have that offer open at this point.
I mean, it was something that I did. I see this is what hospitals is. I don't see
We could do another pretrial readiness on July 27th at 9.
And I can do that. Would the court be all right if we appeared virtually, or would the court like us to be here in person?
One second, please. So July 27th, you may appear virtually,
Thank you.
Ms. Almond.
And what was the time for that? I apologize.
9 a.m.
Thank you.
Yeah, I don't start that until 10 o'clock. All right, so we are going to go ahead and have to call the jurors despite no announcement of ready.
And I will let the court know that if we have this, it'll be at this next date. And if not, again, we will not be causing any delays with getting the trial moving.
All right. The court's going to deny the motion to quash the warrant. Ms. Starks is going to be remanded. Deputy, would you mind taking Ms. Starks into custody? Yes, bond is forfeited. New bond amount that was set on June 1st will remain as is. Who's next?
And this is all that I have until the 4 p.m.s are here. I know that Ms. Giaffretti is finishing up with some of hers. I will need to speak with Ms. Murray at 4 p.m. for a few minutes, and so I'm not sure if the court wants to take a brief recess, but I don't have any more for at least that I see here for this portion of the docket.
All right, court will call 25T39, People versus Gabriel Valerio.
I'm here, Your Honor.
Mr. Valerio appears remotely. What's going on, Mr. Valerio?
I had to move up to Pueblo, Your Honor. I couldn't find a ride down there today. I was trying to find a ride, but I couldn't find a ride at all. I called the court today because I knew the court wasn't open yesterday and tried to find out how to file a motion, and I tried to find a ride to the library this morning to get the papers printed out and get the motion trying filed before 12, but I got it filed around like 2 o'clock, maybe 2:15. I'm sorry, Your Honor. I was just gonna see if I can plead guilty and take the fine.
All right, here's what we're going to do, Mr. Valerio. So, Mr. Valerio, you're set for a pretrial readiness conference today in this case,
Yeah.
and you're asking for more time. Do I have that right?
Yes, Your Honor.
Okay.
Obviously, the time you're talking about, there was no restitution. Exactly. Yes, yes. Restitution purposes, it doesn't matter what the charge is to you, right? So.
So, Mr. Valerio, if you want more time, that's okay, but you have to waive your right to a speedy trial, and I'll explain
Okay.
what that means, okay?
Okay.
Mr. Valerio, I've been told you want to waive your right to a speedy trial. Is that correct?
Yes.
You understand that Colorado law requires that you be brought to trial within 6 months of the day that you plead not guilty to the charge.
Yes.
You understand that by waiving or giving up your right to a speedy trial, you are giving the state an additional 6 months starting right now to bring you to trial.
Yes.
You're pro se right now. So you have not discussed this with an attorney, have you?
No.
Is anyone forcing you or threatening you to get you to waive your right to a speedy trial?
No.
Are you doing so freely and voluntarily?
Yes.
Do you have any questions about this that you would like to ask me?
No, Your Honor.
Okay, so Mr. Valerio has answered the court's questions. The court finds that Mr. Valerio understands his right to a speedy trial and that he is freely, knowingly, and intelligently waiving that right. Can you come in next week, Mr. Valerio?
I can see if I can find it right down there, Your Honor, but if not, I'll have to appear via WebEx again.
All right.
The earliest I can probably come is probably tomorrow
Okay.
because my brother has court in Lahaina and he's getting a ride down there. A ride down there.
I'm not available tomorrow, Mr. Valerio.
Okay.
Here's what I'm going to do, sir. I'll give you until July 20th.
Okay.
We'll have you appear on July 20th. Let me find a time for you to appear.
I think it's different if you kind of in your paper.
All right, Mr. Valerio, I'm going to stick with 3 p.m.
Okay.
July 20th at 3. Please plan to be here in person.
Okay. If I can, do you want me to file a motion to appear virtually?
You got to be here, sir.
Okay.
We got to get down to business. This case is 364 days old right now.
Okay.
So next time we're going to talk about whether you want to enter a plea or whether you want to pursue going to trial. Either way is fine
Okay.
with me, but we got to pick a direction and stick with it. You understand?
Yes, Your Honor.
Okay. So July 20th at 3, we'll see you here in person, sir.
Okay.
Yeah, we're vacating the trial dates as well.
Okay.
Status conference. All right, Mr. Valerio, that'll do it for today.
All right. Thank you.
Okay, so long.
Before we call it, just a logistical question. We have Brendan Mance here. This is a case that is set today for plea and sentencing. We have a slightly modified plea that's going to involve an infraction with a stipulated restitution figure. We, however, don't have a way to print plea paperwork for the amended plea. Is that something, if we can get electronic signatures added, and I would be able to upload it to the court? Is that something that Mr. Mance could handle at the counter?
Well, here's the problem, Ms. Giofretti. I don't have a way to order restitution on a traffic infraction. I don't think that's possible. I think it's fines and points, and that's it. We can continue it so the parties can have more time to talk.
Someone just off the top of my head is another thing I can imagine is probably I don't want to hit them too many times. I think this isn't too that one. True. Yeah. I mean, just stipulate compensation piece or stipulate the restitution piece.
What if we do a class 2 traffic misdemeanor instead of an infraction? In that case, what I propose, which would be if we can upload an electronic document, is that something that essentially we could handle with an electronic plea versus a paper plea?
I think we can accommodate that, Ms. Giofretti. Are you anticipating careless?
We were going to do registration, the fictitious plates charge.
Oh, the fictitious
Yeah.
plates. I don't know. I don't know if I've ever seen anything other than a fine on that. Ms. Gonzalez, do you know whether restitution can be ordered for fictitious plates? I think I'm going to have to continue it just to research it if we're going with fictitious plates, but.
And that's fair, Your Honor. I would note that I've seen it attached to other pleas involving fictitious plates itself, but never to fictitious plates alone. So I'm just as stumped as the court is on that one. But I think because it is a class 2 traffic misdemeanor, we could.
Yeah, I'm confident careless would be something that would work.
My only fear is recognizing that this case originally didn't contemplate a careless driving charge. I wouldn't want to ultimately subject Mr. Mance to a higher penalty than what was actually warranted by the behavior.
Okay.
So that's really my only hesitation with offering a careless driving in lieu of the fictitious plates, recognizing that it doesn't necessarily fit the act that caused the restitution damage.
And here's just so the court has some more context for why we're in this spot. This is a case where initially we were going to be doing a plea with a fine only to a no insurance charge. Mr. Mance had provided proof of insurance obtained, and that was going to be the plea. Subsequent to that, a fairly significant restitution figure came in, which had not been originally contemplated by the parties when we were discussing the case. And obviously, as the court knows, a no proof of insurance charge involves a pretty hefty fine. And at the time that we were going to agree to the no proof of insurance with that fine, that did not contemplate restitution. And so we have been trying to come up with a way that, the restitution can be paid, but that Mr. Mance is not paying hugely more than what he originally had anticipated at the time that he had contemplated entering into this plea. So that's why things are so complicated. It's
All right.
because of a fairly substantial restitution figure that was added.
All right. Here's where I'm at. We've got some other people waiting. I think this is a little bit premature. It'd be preferable if the parties could talk some more and we could figure out for sure what the charge is going to be and whether that charge is restitution eligible. And for those reasons, I'm inclined to continue Mr. Mance's case.
Sure, and I would ask, I understand. I would ask if Mr. Mance could be authorized to appear by WebEx. Coming to court is causing him, and sitting in court is causing him a pretty substantial financial burden right now. He has a new baby on the way. Again, partly why this restitution issue has become so important. And I know he's eager to have this case done with. I understand what the court is saying and why. But I would just ask if Mr. Mance could appear by WebEx at the next appearance, so at least he's not dealing with that hassle. I'm sure he and I will be able to get paperwork back and forth once the parties come up with something.
All right, Ms. Gonzalez?
No objection from me, Your Honor.
All right, let's continue this matter until August 3rd at 3. Let me just take a look at something. That will be a final arraignment.
Okay. And I think technically we hadn't officially called this case on the record when we started talking. It had begun with me asking about electronic pleas. So I don't know if we can just make a statement on the record that we have been discussing Mr. Mance's case, and the last 3 or 4 minutes of the FTR is regarding Mr. Mance.
Okay. Mr. Mance can appear remotely next time. I do need to be able to see his face. And anything further?
Not from the people.
Not from the defense.
Okay. August 3rd at 3, Mr. Mance. You can appear remotely if you want, but you got to be able to appear by video, sir. All right. So long. Thanks, Sheriff.
And then I know it is just a few minutes early, but I did speak with Miss Murray and with Miss Gonzalez earlier. So if we could call the 24T34 case, I don't believe this will take very long.
Protocol case number 24T34, People versus Terry Murray. Ms. Murray appears in person with her attorney, Ms. Almond. Ms. Gonzalez appears on behalf of the people. We're set for a motions hearing today. What is going on with Ms. Murray's case?
And Your Honor, we do have motions in this case. I can let the court know that I did speak with Ms. Gonzalez about ways of trying to get this case resolved. And because we wanted to be able to speak together, we agreed that so that we can avoid having to do more than we need to if we can get this resolved. Ms. Murray has also agreed that we can set the motions hearing at this next pretrial readiness date. And if the motions hearing goes forward, then we can have everything going. But at this point, we think that we should be able to get this resolved without needing to go to a motions hearing today. And so that would be our request, so that we can work together. The last time that I was able to speak with any kind of DA was back when this was Mr. Cohen. And so Ms. Gonzalez and I need to do some catching up on the circumstances for this so that we can get everything moving.
Ms. Gonzalez?
And Your Honor, in speaking with Ms. Almond, I'm confident that we can likely reach resolution in this case. I would, if the court is willing, possibly just postponing motions for that first pretrial readiness conference, with the understanding that if a resolution is not reached, then we'll just proceed on the motions as is. But I would note the procedural history of this case is a little bit messy given transitions in my office. And so I would certainly appreciate the court's graciousness in allowing us some more time to chat.
And I will let the court just know, just for the record, that we were prepared to have the hearing today, but with speaking with Ms. Gonzalez, I think that this would be a better resolution for every party here to try to have this resolution before we go to the actual hearing.
Ms. Ullman, I can give you 2 weeks on the motions hearing. I'm not inclined to shove everything to pretrial readiness day. It presents an inconvenience for the court
And it
for
would just,
scheduling purposes. So the other thing is this case is 791 days old. This may be one of the very oldest cases I have. So I cannot tolerate any more delays.
and I understand, Your Honor. I guess for me, it would depend on the specific date of what the court would be requesting for.
It'd be the 20th of July.
And I can do that. And Ms. Murray can also do that. That would be our request.
All right, then. All right, we can do July 20th at 10:30. I don't mean to be abrupt with people, but at some point we just gotta figure out which way we're going and
Yes, Your
stick
Honor.
with it. July 20th at 10:30 for pretrial motions. Let me just check one more thing, please. Ms. Murray, your bond is also continued until July 20th at 10:30 a.m. We'll be in recess in this case.
I'll call you to make sure that matters.
Yeah, sure.
To delete, press 7.
We have somebody on WebEx with a telephone number that ends in 30. Who's there?
Mr. Salazar, I've been brought up to speed on the situation. I'm sorry that you were unhappy with the representation from my office. It sounds like you filed a motion to get a different lawyer. My attorney, Mr. Freddie, indicated to me she felt there was an irretrievable breakdown of the attorney.
What is your name?
Conflict in your case to where you will get an attorney from outside of our office. That has been filed, and so the court will be appointing you a new attorney soon. And so I would look for that and make.
What is your name?
Salazar, and this is Justin Hainline.
Oh, is that Mr. Salazar? Okay.
Would that be me? Are you even there?
Court will call 26722, People versus Philippe Salazar. May I have the appearances of the parties?
Danielle Gonzalez on behalf of the people.
And Justin Hainline on behalf of Mr. Salazar.
And Mr. Salazar appears remotely. We're set for pretrial conference today. Mr. Hainline, I understand you have not been on this case long. Are you seeking an additional pretrial conference?
I am, Your Honor. I have received I do need to get with Mr. Salazar to discuss the discovery as well as receive an offer from the people. So I would request an additional pretrial conference.
Very well.
No, I do not wish to move forward with that motion. I wish to enter not guilty plea. I don't know who this gentleman is that's in there on my behalf. I've never been introduced to him. He's never introduced himself. He's never called my phone. He's never reached out to me. I don't know how somebody could be in the best interest of you if they're not reaching out to you before you approach a court appearance.
Mr. Salazar, if you interrupt, we're going to have to mute you, sir.
I'm not interrupting. I'm defending on my behalf.
Yeah, well, you're represented by counsel, so your attorney's representing you today.
I was never made aware of this, which is a right of mine. I wasn't made aware of this.
Well, we're trying to make sure that
You're trying to do
your rights are met.
They ain't met because I don't know this man.
Okay, well, most people take time to get to know their attorneys and don't know them so well on the first day.
But he's even introduced him.
Okay, Mr. Hainline, are you waiving further formal advisement, sir?
Understand, I haven't even been in a period.
We're going to go ahead and mute Mr. Salazar, please.
And Your Honor, I will advise Mr. Salazar. Mr. Salazar, I've only briefly been appointed on your case. I don't have a number for you. At the end of this, I would ask that you give me your number and I will call you right after court.
Mr. Hainline, are you available either August 10th or August 17th?
Let's see. I think I can do the 10th, Your Honor. Would it be in the morning?
Let me find out.
I'm also happy to do the 20th. If Mr. Salazar wants to speed things up, I'm available that day.
All right, I am not available on the 20th.
Oh, okay. Okay.
Do you have time for us on August 10th at 1:30, Mr. Hainline?
I do, Your Honor.
All right. August 10th at 1:30. Let me just check one more thing here, please. Mr. Salazar's bond is also continued until August 10th at 1:30. All right, I think that'll do it unless there's anything else that the parties want to put on the record.
Nothing additional from the people.
Your Honor, may I just have Mr. Salazar give me his phone number? If there's not a number in the file, so I need to get a hold of him somehow.
All right. Let's unmute Mr. Salazar so that his attorney can get his telephone number.
I'm unmuted. Let's understand this, all of you. I'm charged with calling a government agency from my phone, and none of you have the phone number that fits within the Crowley County Judicial Building?
Mr. Salazar, you're ordered to give the telephone number to your attorney.
Change of venue, sir. The first thing he needs to file is a change of venue today. I'm asking my attorney to file a change of venue today because Crowley County is corrupt. Every one of them, including the judge.
Do you want me to find you in contempt?
Sir, you guys have the number. You are not being fair. The Crowley County court system has my phone number. You're going to find me in contempt. blame Miss Pepper or Miss Marisol. They have the phone number. I'm
I'm
charged with the
ordering
criminal.
you to give your attorney the telephone number that you use. What is your telephone number, sir?
I don't even know the attorney you speak of because he hasn't even introduced himself.
Okay, we'll talk about it on August 10th at 1:30.
But you guys have the correct information to give him, Your Honor.
This case is now in recess. Good day to you, Mr. Salazar.
You have the information to retrieve to him, though, Your
We're
Honor.
done. Goodbye.
Well,
Thank you, Your Honor.
Thank you for your help.
And then I'm ready on the Kristen and Naya case. That's our last remaining 130.
Court will call case number 26M6, People versus Kristen Anaya. As Anaya is here in person with her attorney, Ms. Giofretti. And Ms. Gonzalez is here on behalf of the people. We're set for a pretrial conference. Where are we with this particular case?
And Judge, an offer has been extended. I had sent Ms. Gonzalez some documentation and information along with a counter offer. I believe that generally speaking, the counteroffer is acceptable provided VRA is completed. So that's what we are waiting on. My request would be to set this over to the next docket. And then I can tell the court that, again, provided that VRA is successful and that this plea proposal is acceptable, this may be a situation where the case can even be resolved prior to that August 3rd date with Ms. Anaya completing some things before court. So I think we're very close to being done here.
Any objection?
None for me, Judge.
We'll continue this case until August 3rd at 1:30 p.m. And that'll do it. We'll see you then, Ms. Anaya. Good day to you.
Thank you, Honor.
Have a good day.
And then I'm ready on Dennis Ackerman.
Court will call 25M66, People versus Dennis Ackerman. Mr. Ackerman appears in person with his attorney, Ms. Giofretti, and Ms. Gonzalez appears on behalf of the people. We're set for a sentencing hearing today. Have the parties had enough time with the pre-sentence investigation? I noticed it just came in recently.
Judge, it did come in fairly recently. This is one that at the time we set this, we knew we were going to be cutting it kind of close. And I had indicated that, I would be able to make it work as long as I had it a couple days before court. That did come in on July 1st. I have had an opportunity to review it with Mr. Ackerman. And I am ready to go forward today. That said, I do recognize that it's because Friday was a holiday. I think the parties have only had this about 2 business days. And so I also understand if anyone needs more time.
All right. I've had enough time with the PSI. The only thing I wanted to say about the plea agreement is I think we need a date certain by which Mr. Ackerman is to begin his 30 days. I think we talked about that on the day that we were here with the jury pool. And I think what I have is still from that day, and it has not been altered at all.
So the proposal. And Judge, I think the parties are in agreement that a deadline to start 60 days from today would be acceptable.
Okay,
Obviously, if we end up in a situation where Mr. Ackerman finds out that bed dates are not available until after that or something like that, I could file a motion. But understanding the court does need to set a deadline, I think 60 days is acceptable to everyone.
yeah, I just need to have some way to enforce it and not have Mr. Ackerman wait till the 23rd month and say, well, you know, it's not time for me to start yet. So if 60 days from today is going to work for the parties, I'm inclined to go along with that. All right, let me just take a look at something. All right. So Mr. Ackerman did enter his guilty plea on May 18th, so we are ready for sentencing. Court will hear from the people.
Thank you, Your Honor. And I would at this time ask the court to sentence Mr. Ackerman in accordance to the plea agreement as proffered. From my review and as well as from my recollection, the plea offer contemplates 30 days jail ordered and suspended upon completion of a 30-day inpatient treatment stay, as well as 24 hours of use of public service, and for that proof of completion to be tendered to the court. I know the court agreed to the September 6th date. That being said, it does take a little bit of time for individuals to get a bed date, especially those that are circumventing the probation process, since I do know that the probation department does have an ability to get those bed dates a little bit sooner. But I don't have anything additional to add here, noting that Mr. Ackerman ultimately did take responsibility for his role in this particular case. He looks like he is amenable to treatment as contemplated by the plea offer here. And so with that, I would just ask the court to sentence him accordingly. But with that, I have nothing further.
Ms. Giuffretti.
And, you know, a lot of this I think was said back on May 18th when we were discussing this resolution mid-trial. So I'll keep my comments briefer than I maybe otherwise would. This is a somewhat unique circumstance. This is a case in which if we had just been dealing with the possession of a controlled substance charge from the start, I doubt we would have ended up at trial. The situation was that there was originally also a gun charge that at least my assessment was that it was very, very clear that that firearm did not belong to Mr. Ackerman, but belonged to the driver of the vehicle. And that charge ultimately was dismissed the night before, or the day before, excuse me, trial, and then we were left in a situation where we were going to trial on, you know, a DM1 for possession of approximately 0.2 grams of methamphetamine. Then there were some issues that were revealed also mid-trial about some documentation that the CBI had that had not made its way into discovery for either defense or prosecution. And so that's why this is a somewhat unique resolution. But I think in light of all of that, in light of the fact that Mr. Ackerman's only adult criminal history is a harassment misdemeanor back when harassment was an M3 in 2019. He has one juvenile adjudication. Other than that, though, Mr. Ackerman does not have a criminal history. He comes to court. He's never caused any sort of problems in court. He's never been disruptive in court. Especially when all we were dealing with was a drug charge. I think that what everyone is focusing on here is giving Mr. Ackerman an opportunity to get treatment. And this plea does contemplate that. And so I'm just asking that, in light of the unique circumstances of this case, that the court accept the plea. Thank you.
And Mr. Ackerman, you don't have to say anything before I sentence you, but if you'd like to say something, this is your opportunity here. Okay. So the court's going to enter the following sentence order. Mr. Ackerman, I hope that you've learned something from this and that you spend the time in treatment thinking about your life and whether you want this kind of thing to go on for yourself. This goes beyond you just being in the wrong place at the wrong time, like the PSI said. You got to think about who you're choosing to associate with. You had facts that were in your favor this time. This case was a bit of an anomaly, but the next case might not be that way. So I hope you take this seriously. Drugs will take everything you've got. And when they've taken everything that you do have, they'll take your life. So I hope you're ready to make some changes. Everybody here wants you to succeed. So the court's going to enter a judgment of conviction for the added count of controlled substance, unlawful use, under Colorado Revised Statute 18-18-404 subsection 1, a class 2 drug misdemeanor. All other charges are to be dismissed. Mr. Ackerman will perform 24 useful public service hours. I'm going to set a date for the UPS hours too. I want you to go get the treatment done first because that's more important than UPS hours. But UPS hours are part of your sentence, so you're going to have to go do them. The 24 useful public service hours are going to be due by November 9th. I think 9 or 10 o'clock. 9. November 9th at 9. That'll be easy to remember. No restitution is owed. Mr. Ackerman is ordered to not commit any new criminal law violations during the term of the sentence. 30 days of jail are suspended upon proof of completion of a 30-day inpatient stay. Let me see. Court's going to suspend a $250 fine upon condition that Mr. Ackerman complete the 24 useful public service hours by November 9th. And that'll be the court's sentence. Anything from the parties?
Nothing additional from the people.
Not from the defense, thank you.
All right. And Ms. Gonzalez, do you want to make the review date on November 9th for useful public service hours and the completion of the 30 days?
That works great for me, Judge.
Okay. So the review date will be for purposes of determining whether the UPS hours are done and the 30-day inpatient stay.
And I'm just not familiar with how this court does review dates. Is that a non-appearance date that the court reviews, or is that a date that Mr. Ackerman needs to appear by?
If we receive documentation that he's done everything that he was ordered to do, and by everything I mean the UPS hours and the 30-day inpatient stay, then I'd be in a position to vacate the review date. If I do not receive those materials, or I just receive one or the other, then Mr. Ackerman does need to be here.
And that was November 9 at 9.
Yeah.
Okay.
All right. Anything further?
Not from the defense, thank you.
Not from the people, thank you.
Okay. Good luck to you, Mr. Ackerman. I hope you make it.
And then my remaining case is Benjamin Wilhelm. Before we call it, this is one that we had a somewhat lengthy discussion back on the motions hearing date on June 16th. And at that point, I had indicated that setting today may not allow me much time to get things done, just given my own schedule, but that we could try for it, and that certainly Mr. Wilhelm was already set here for a pretrial readiness before we had vacated the jury trial. So I would defer to the court and Ms. Gonzalez if we want to take a few minutes to discuss Mr. Wilhelm's. She and I want to take a few minutes to discuss Mr. Wilhelm's case now, or whether it's better to come back. I want to be respectful of everyone's time. I'm happy to take a few minutes now, but I'm also okay with setting over.
All right. So Mr. Wilhelm has been here with us this afternoon. He's also been with us for the last 371 days. So if the parties want to take a recess and talk, that'd be fine. I'm not sure we're going to achieve much by the time you get done talking, but I'd like you to make an attempt, please.